Okay, so the second speaker this morning is Norman Fenton, who needs no introduction, and is talking about Bayesian networks, challenges and opportunities in the law. Norman.
Thank you. Well, having presented 2 seminars and 1 formal workshop talk already during this program, I decided to prepare this talk as late as possible, not just out of desperation for saying anything new, but because I decided that I would actually respond to some of the discussions and questions that have been raised during the program so far. There are many, and because of that, there are actually many people who I'll acknowledge during the talk as we go who have contributed to this. So this is kind of like not just my ideas, but quite a few other people's. But I just make one restriction on the scope of this talk, and that's the same restriction in scope that I had in my first workshop presentation, which is that I'm talking about Bayesian network models at kind of a fairly high abstract level in an attempt to incorporate all of the kind of evidence in a case. So that's more akin to the kind of model that Phil David was presenting yesterday, and also that Charles just presented, rather than the more detailed models that, say, Julia Maltera and Peter Verheer presented yesterday, which I would regard as being the detailed components in the way, again, that Phil explained in his object-oriented model yesterday. So I'm going to basically talk about the opportunities, by which I mean benefits, of using Bayesian networks, or the ones which I think where there's some new ideas which have come out here. There's going to be a few of these, but the ones I'm going to focus on are these particular ones, and also look at the challenges that we've been especially considering during the discussion so far. So in terms of the opportunities, I'm just going to list what I think that they all are, and then focus. The ones at the bottom are going to be the ones that I'm going to focus on. So at the first presentation, the key point that I was making was that Bayes, and in particular Bayesian networks, actually are they actually represent in a very intuitive way what actually happens in legal practice and reasoning, which is that you have uncertain hypotheses, you see evidence, and you basically revise your beliefs about your unknown hypotheses, okay? And I think, again, a point that several people have made, and Phil certainly made this point yesterday, is that we found that just the act of actually developing a Bayesian network helps us, even if you don't have the numbers, actually helps you understand the key components of a case and the evidence. I mean, the same is kind of also true for the approach that Henry and Verheer and Flores also talk about, and that's going to be something that they'll discuss. So that applies to those approaches as well as Bayesian networks. I believe that once you do have some of the numbers, right, then they can help determine whether a case has sufficient evidence to go forward. And the thing that I focused most on in my first talk was this problem. I think that they expose some weaknesses of what I regard as focusing and relying on what I called the oversimplistic likelihood ratio approach. And I actually think that the question that Bill Thompson just asked of Charles, again, that's something that I think was absolutely central to that issue. So the things that I'll just then, the new things are about this whole idea about better understanding and explaining the impact of evidence when there are complex dependencies. That's coming up all the time. And this one, which I was particularly keen to bring in this example because Phil Davis here, and it reminded me of something that he did that I want to talk about, which is how Bayesian networks are actually really, really good at defeating traditional objections to the use of Bayes and probability in the law. And finally, a thing that came up in the first workshop and caused a lot of interest. This was a problem proposed by Anne Ruth McCaw about how to deal with novel and surprise evidence. So first of all, this is a variation of something that I did mention at the first workshop. So the whole idea is that we've got what we think is evidence that there's some DNA match, for example, at a crime scene. Okay, and ultimately we've got the kind of the So this is the, I guess, the activity level hypothesis. What's it?
Can you read out the illegible stuff on your...
Oh my God! It's perfect.
Your colour blindness is...
This looks really dark green on here. It says E, defendant DNA matches DNA at the scene, yes or no.
It's illegible, basically.
It's like really, really dark green on here with a white background. Okay. Okay. You know, you ultimately want to be able to use that sort of evidence to say something about that, but of course we know that, of course, there's sort of the intermediate source level hypothesis, which is that the defendant is actually the source of the DNA at the scene. But actually, this thing here, which you can't read, which is supposed to be evidence, is not really evidence. It's actually also a hypothesis which is unknown. You know, we don't know whether the DNA matches the DNA at the scene because we have to rely on an expert. Sorry, that's the same thing. This is an expert who testifies that the DNA matches the DNA found at the scene, right? So we don't know. That's our unknown hypothesis. And of course, that depends on the expert credibility. And this, that depends on this expert credibility, which is exactly the point that Paolo Garbolino was making in his talk yesterday, which is that, of course, whether or not you believe that hypothesis depends on that. Now, I'm just taking a very simple view of credibility here. This can be expanded in exactly the way that Paolo said yesterday, but just let's assume for simplicity it's what he said. And indeed, the way we would define the conditional probability table here is exactly the way that Paolo did it yesterday, and that's what we do in our examples. And this is what we call the classic, what we call, with Dave Lanyardo and Martin Neal, we call this the classic evidence accuracy idiom, which is a variation of a measurement idiom, and we think it's kind of like central for building most of these sort of legal arguments. But of course, again, we got things here. This one says W, a witness testifies that the defendant was at the scene, because we're going to have sort of eyewitness evidence of that. And of course, that's going to depend also on the witness credibility. Again, exactly the same idiom applying there. But of course, ultimately, what we're interested in is the ultimate hypothesis, whether the defendant is guilty or not, which is going to be conditioned on hypotheses like whether or not the defendant was at the scene and therefore having opportunity. Now, of course, when you put this all together, right, and of course, I'm not going to go into the details of this. This was a sort of an example that Dave and I built on the classic Collins case. You can actually do things like enter the evidence that you've got, which is based on all this sort of credibility, I've called it reliability here evidence, and come up with a posterior belief as to whether the Collins were guilty or not, which we think they were actually based on the evidence. So you can do that. Of course, you can argue about it, and the problem is, as I think Henry Pracken said yesterday, the problem is, how do you arrive at such a model, right? And why should we believe it, especially as two different Bayesian network modelers would almost certainly come up with two quite different models, even if they were trying to pitch it at the same level of abstraction. And a major research theme, I mean, this whole idea of this, what we call the idioms-based approach, is indeed attempting to provide a structure and a method for, let's say, minimizing the variation in the models that people come up with. So that's what we think is a sort of we see that as a key objective. Coming on to the problem of the surprise evidence that Anne Ruth McCaw raised, she called it the novel facts problem. What we've got is the following. A defendant is accused of murdering his wife and offers no defense other than a denial. He didn't do it. Okay, so again, we've got a classic, if that's all we've got a classic case of this witness credibility, this evidence accuracy idiom. Now, we've got his statement that says it wasn't him. Of course, that should inform us in some way about his guilt, okay, but of course it's totally dependent on his credibility. Now, the thing is, so there's no other evidence to support his denial. Now, later on, subsequently, evidence of DNA of an unknown person is found on his wife. Okay, so how do we interpret that evidence? And this, I'll credit, so Dave and also Bill have been involved in these discussions, so I credit them with what I'm going to say now. So if you don't like it, it's Dave. It's Dave's. So of course, what happens is that is that the impact of this new evidence critically depends on whether or not you think he knows about the possibility of there might be some other DNA evidence that might come up, right? Because, so for example, suppose he was aware that his wife had had intercourse with her lover on the morning of the murder, okay? Therefore, he knows there's a very good possibility that the investigators will find that other person's DNA on his wife's body, okay? Now, if he knows that, of course, that gives him the kind of excuse then to simply say, I deny it, of course, in the hope and expectation that he's going to be kind of like validated when they produce this new evidence, okay? So actually, when we putting in some simple prior assumptions like 50-50 guilty, 50-50 credible, we assume a low probability that he knows about this other evidence, right? Because, you know, if you're investigating the case, you wouldn't assume that someone is hiding some evidence, right, that might help them, would you? Okay? So now we enter the evidence, the initial evidence. He says it wasn't him, right? And using exactly the method that Paolo said yesterday, that does slightly update it updates your belief that he maybe isn't guilty, not by much, because we don't know anything about his credibility, but he's given a denial, that's something, right? He didn't admit to doing it, right, which would have obviously been different, right? So that doesn't really tell us very much, right? When we get the DNA evidence now, right, with our prior assumptions, we get a massive change. This has massive impact, right? We're now almost certain that because it kind of like, it provides this sort of apparently independent validation of his story, okay, completely independent. So not only does it suggest that he's innocent, but it also increases our belief in his credibility, okay? But the difference is, it's all about this, does he know? If it turns out actually he knows, he knew about it, look what happens. It's completely different, right? Yes, it's still more likely to be not guilty than guilty, but we're more or less getting back to where we were at the beginning, actually, okay? And we're actually now starting to doubt his credibility. So I think that I kind of think this addressed it in the way that there was a lot of discussion about this in the way that I think that Anne Ruth was hoping. Now comes on to where another, again, let's say a sadly neglected area of Bayesian networks is in addressing the problem of classical objections to the use of Bayes and even generally probability in legal arguments. Now, this is motivated. There's some old stuff here, right? Because basically, Cohen in 1977 raised these classic problems of why probability was inconsistent with legal arguments. Pardo produced, I think, about 20 examples in this more recent paper based on Cohen's examples and new ones, where he more or less said, look at these, these situations, these scenarios prove that probability doesn't work because it contradicts legal intuition, okay? But of course that reminded me that Phil David, just one of these, I mean there are lots, because we've actually resolved, we haven't written this up yet, but only a small amount, but we've resolved most of these simply by articulating them properly as Bayesian networks, rather than trying to squeeze the probabilistic argument into the wrong basic model, which was what Pardo and Cohen were doing. Phil David very eloquently provided the rationale as to why one of these so-called paradoxes wasn't a paradox. And Phil, you did it formulaically. So this solution I'm going to give is exactly the Bayesian network equivalent of your solution. So there's nothing new here. So this is the example. So the claim, this is the so-called paradox, that you've got a civil case which is based on the conjunction of independent claims, A and B, by two witnesses to these things, and the witnesses are assumed to be 70% reliable. This is sort of paraphrasing what Cohen and Pardo wrote. So Cohen and Pardo say, well, that sort of means that the probability of A being true and the probability of B being true is 0.7. Well, there's a problem with that, because that's not exactly what you're assuming. You're assuming something about their reliability, not about the truth of what they're saying. So there's already an issue. And so he says, so individually, each of the facts meets the 50%, 0.5 threshold for guilt in a civil case, okay? But the conjunction of the facts, the classic probability, they say doesn't work here because when you multiply them together, they're independent. The probability is 0.49, okay? And then, so they said, I think this was a quote from one of these, I can't remember which, but each witness clearly offered positive support for the plaintiff. How can it be that their combined support undermines his case, hence Pascalian, well, probabilistic approaches fail? So they claim in it fails, it doesn't represent, you know, what intuitive legal argument should be. So, but the solution, and so this is the Bayesian net of your solution, Phil, is actually, and again, it's exactly using Paolo's the evidence credibility. So you've got one of those idioms here and you've got one of them over here. Okay, so what we really know is that each of the witnesses we can believe in their reliability is 70% reliable. That was the actual thing you're saying, right? At the moment, they haven't made any statement. They're going to make a statement about the truth of A and B, respectively, right? And at the moment, we're assuming 50-50 priors for whether these events are true or not. We don't know. When you observe both of these being true, what actually happens is that because of that 70% belief in their reliability, there's an 85% probability that each of the individual events is true, and the combined probability easily beats the 50% threshold. Hence, no paradox, because you just do it. We've articulated the problem into its components, which is how you resolve all of those other so-called paradoxes raised in that Pardo paper. So on to the challenges. So these are kind of, we had a lot of discussion. We had a workshop with let's say the Dutch argumentation scenario people where we worked jointly on a very complex and real murder case, but where the idea was to come up with these models and see which ones perform best, and that's going to be reported tomorrow, I think, so there'll be some discussion about that. And of course there was a lot of discussion about this whole thing about getting the numbers, and that's of course come up over and over again. And of course that's dependent on sort of prior, this what I call the prior and background information problem, which I'll talk about, and in particular incorporating motive and opportunity. And then, and this was a very, very common theme, and it also leads into the thing that we're most concerned about at the moment with these models. It's, should we be modelling what the lawyers present, so that, you know, the prosecution presents its case and the defence may or may not present its case, okay, and these may be completely conflicting. They may not represent what we believe to be the true state of the world. Again, you got questioned on this as well yesterday, Bill, about what should we be modelling here. And that's a problem. That's a problem because then you get the tension between what we're supposed to be doing with the models and whether that is consistent with the legal process. And in particular, that's a special case of this whole problem of how we integrate alternative conflicting narratives. Okay, it's a major, major problem for Bayesian networks, okay? And then the problem of how you actually communicate the model and its results to lay people. So going back to that thing that you can't read again, remember this was whether the expert testified. So simply, well, again, the only point I was going to make here, some of these things are easy, okay? So things like that H3 hypothesis, DNA match, that's where you get your DNA experts, you get your likelihood ratios. I wouldn't say it's easy, but that's the sort of thing that's where that stuff comes in. So that's where that's where you get your numbers for there, right? Things like this, you get your numbers in the way that Paolo told us yesterday. There's nothing particularly controversial about that, okay? But of course, the controversial stuff is all at the top there. And if you do want this complete model, if you're not just focused on, and again, the argument I made in the first workshop, is you can't ignore the impact of this on those things at the top, and therefore you have to think about priors and conditional probabilities for the stuff at the top, and that's the difficult stuff. That's the really problematic stuff, of course. And again, some of the stuff that we've been talking about during this, again, workshop, and I attribute all those people I've mentioned have been involved in these discussions, was this whole thing about just getting the prior for defendant guilty. Now, this is already controversial because most people assume you shouldn't even have defendant guilty people say you shouldn't have defendant guilty in a model anyway. That's for the court to decide. But if you actually want to look at the impact, if you want to look at the likelihood ratio of all of the evidence on defendant guilty, you've at least got to make a 50-50 prior there. But the problem is, even that you can't really do, because actually it's conditioned on other information. It's not unconditional. We used to think you could get away with the defendant guilty node having no parents. And this is a discussion that we've had for 6 weeks now with Richard Gill on this. It's a very difficult question. Because if it has no parents in a Bayesian network model, then you can say, okay, well, it doesn't matter. We'll take whatever prior you want. So we're not being kind of like, then we can look at it over a range of priors. But that is not, in reality, you cannot do that. In the case that we've been discussing, right, what we've actually got is a murdered wife next to her husband in a deserted forest, right? The murdered wife and the fact the husband's with her at the scene is background information. You cannot ignore that, okay? And so in those kind of situations, we've come up with this type of thing where, how many other people are possibly at the scene, right? If there could only been 20 people at the scene, and if you assume neither the defendant nor any of the others had any particular motive to murder, then a 1 in 20 prior seems, a reasonable conditional probability in this case. Okay, and there's a lot of discussion. I mean, my preference is always actually if you could start with a 1 over world population prior, and then narrow it down based on the evidence about location and all that sort of stuff and opportunity. This is a sort of a logical extension of that, actually. So that's the kind of way we're just handling that. The final problem then, and the most difficult, is this one about integrating conflicting narratives. Now, what we've got here is a situation where we haven't just got two alternatives for, let's say the outcome of a crime or even a potential crime. We've got hypotheses about a person X, right? The suspicion is that there is basically a defendant is being charged with the murder of X. But actually, we're uncertain not only about whether that hypothesis is true, but of course whether X could have been murdered by a different person, X could have committed suicide, X may have died naturally, X may have died accidentally, X may still be alive because X's body hasn't been found. X has basically vanished. Okay?
Or this person killed X, but it wasn't culpable homicide.
That could have been, exactly, that's another one as well. Okay, good. Now, the problem is, by definition of a Bayesian network, because those are the states of, if you like, the status of what we know about X, right? Those are mutually exclusive and exhaustive. Okay, so if one is true, all of the others are false. Okay, and their probability is summed to 1. The problem is that if you try and do that, this is a Bayesian network, right? But if you try and actually now start to elicit probabilities here, you are in an impossible situation. Even if all of those parent nodes, even if all of the parent nodes have just two states, they're Boolean, okay, then you've basically got to fill in 768 different probabilities in this table here. Okay, and those probabilities include absolutely nonsensical combinations of things like, whether X died accidentally, given that D has got an alibi and he did or didn't often swim in the sea, or he lost all his money, etc. I mean, it just doesn't make sense. You've got to consider all the possible combinations. It's ridiculous. Okay, and similarly here, so you've got the possible causal factors leading into those they're different narratives actually, and then you've got the kind of the evidence factors coming out of it, where also you've got to ask ridiculous, so what's the probability that we find an evidence of a struggle at the apartment, given all of those different combinations of stuff up there. It's clearly ridiculous, right? Although again, this is something that we've had our disagreements, by no means we've had our disagreements about, okay? So the natural way to do it is to think that these are different narratives, right? So some of that evidence, some of the causal factors only apply to some of these hypotheses and not others, and clearly not others. Similarly, some of the evidence only applies to some of the hypotheses and others. There is some commonality here in the evidence that you found, but probably not in the causal factors. That's the way you'd like to do it. Yep. Separate them out. Make, let's say, each of these hypotheses Boolean, they're either true or false. That is provably logically incorrect, that model. Okay, for the simple reason that no matter how you construct it, you will not be able to construct it in a way such that those things which you know have to be mutually exclusive are mutually exclusive. It can't be done. We proved it can't be done. We've written a paper on it. And in fact, it turns out that the tricks, there were some proposed tricks for, before I say that, here's a much more simple example. I think this is the one which originally alerted us to this problem, because we had to solve this particular problem where we had an alternative prosecution and defense narrative to explain a piece of evidence, like defendant blood was on the victim's shirt, and there were two alternative narratives which required these two things to be mutually exclusive, and we basically, even for that simple problem, it proved remarkably difficult to solve, because how do you force two separate nodes of a Bayesian network to be mutually exclusive? Well, yeah.
Which two are you talking about?
In that case, I was talking about these two. No, the middle two,
Can I
mutually
make a
exclusive.
suggestion how to
Yeah.
do that then? You have another node hanging off those two.
Yes, the constraint node solution. So the constraint node solution was proposed in Jensen's book, right? And people assume that's the obvious way of doing it. It doesn't work, and it doesn't work for the simple reason that this is the actual solution. I didn't put the constraint node solution doesn't work for the simple solution that if the prior probabilities are not of the two things you want to be mutually exclusive are not equal, then when you do the constraint node solution, you basically lose the prior information. It doesn't preserve the prior information. Okay? Now this is all proved. Now the great thing here is that this is hot off the press, because as of today, and I mean literally today, this paper, which took us ages to finally get published, is now available in gold access, because I decided to stump up the $2,500 to Elsevier. I was so determined to get it out. And all six of these authors are actually in the audience here. So it's kind of like almost a celebratory moment, this. Sorry?
Champagne later.
Absolutely. And it proved that the Jensen solution and all other simple constraint solutions didn't work, and produced a not particularly elegant, I mean, it's quite a neat, it's a trick to basically force it where you introduce an auxiliary node, and it's defined like this. You can do this because this hangs off, so it's kind of like independent. You can still have all your separate narratives, right? So this is sort of almost hidden from the network, but it just ensures the mutual exclusivity, and to preserve the probabilities, to preserve the priors, you have to set the MPT of this constraint node to that, so when the constraint is true, you've got your priors preserved. And that doesn't happen with Jensen's solution. Okay, so that was the trick. The problem is that it's only a partial solution. Why is it only a partial solution? Because unfortunately, if we go back to one of these, imagine you had a whole load of stuff at the top and a whole load of stuff in particular coming down here. You know, part of the narrative gets extended, so he was here at this time, and then he was seen at this place at this time, etc. Although it ensures mutual exclusivity of the things you started with, it doesn't ensure mutual exclusivity of stuff down here, which has to still be mutually exclusive. You've got to basically do the constraint node trick again for all the other things that you want to be mutually exclusive. So it's basically a problem, right? Hence, Martin Neal, in his talk, right, is going to present a completely different strategy for dealing with this problem, which we see as one of the most difficult problems for using Bayesian nets in legal argumentation. Okay? No pressure, Martin, don't worry. And just finally, the final point about communication, I'll just skip this very quickly. So again, the sort of the argumentation scenario approach, we see that as kind of like helping inform what you're not supposed to be able to read it, don't worry, to help sort of inform what the Bayesian network model actually is, and then use the Bayesian network model to come up with actual probabilities for different scenarios. So that's where we see the way forward. Now, in as long ago as 1991, so we're at the 25th, the 25th anniversary of Ward Edwards making this statement when he actually, interesting enough, used Bayesian networks in the Collins case and came to actually a slightly different conclusion to us. Anyway, he made this assertion. Brilliant guy, brilliant paper. But he made this assertion. I assert that we now have a technology that's ready for use, not just by scholars of evidence, but by trial lawyers. 25 years later, clearly he was wrong, which is a shame. So in summary, I think that this is a point that I think that Giulio, is he here? That I think this was a key point that Giulio made, at least implicitly in his presentation yesterday, which was that one way or another, when you're dealing with sort of, observations and evidence and updating your beliefs, that somehow your fact finders, whoever they are, whether they're Bayesians or not, they are somehow internalizing a Bayesian net structure, and they're arriving at their decision based on something like that, right? Whether they realize it or not. And as far as I'm concerned, why not make them explicit? If the Bayesian networks make explicit the stuff which is generally hidden, and in particular what these kind of like hidden assumptions and hypotheses, which as we've seen in a number of cases were the crucial things which were not made explicit. And this thing about the witness credibility thing, it's all about this distinction between the truth about an unknown hypothesis and reports about its truth. In a lot of the early Bayesian networks, it's not so much a problem now, but actually you still see it in Bayesian network models of cases, and not just in the legal sense, very much in the medical case, which I think Barbaros might talk about, where things which are clearly just measurements are assumed to be the fact. So you've got a measurement about something that you're really unsure about, again, Giulio's point, and it's assumed to be that is the fact, whereas what they should be doing is taking account of the uncertainty of the measurement instrument or the credibility of the person reporting it. And then, of course, the thing about Bayesian networks, and again, another point that Giulio was making, they do compute the overall results of all the assumptions and evidence, right? And you can't do that manually. People, you can demonstrate. There's no way that people can do these calculations in their head. It's hard enough, even if you've just got a two-node model, just apply Bayes' theorem, let alone when you've got a more complex model. And finally, I don't think they're ready for presentation in court, but I think that a lot of the commonly cited objections to using Bayesian networks for legal arguments are being addressed, and we're sort of making inroads all the time. Thank you very much.
Okay. Yes, Christian first.
Yes, you made a point about that the ultimate hypothesis can't be apparent without parent because motive and opportunity is, as you said, some kind of background information that's already there. And so the way you describe it is there is no starting point where that information is not already in, so to speak. But I'm not sure that's right, because if you look at how a criminal trial plays out, it starts with a statement of the criminal act as charged, which does not include that information. It's simply that X killed Y in that way at that date in Rotterdam or whatever. So why can't you just say that, okay, that's where we start, the criminal act is charged,
Yep.
That's the hypothesis, and when we later know that, okay, so at this place there were only a few people because it was deserted, or we know about a certain motive, that is actually regarded as evidence and can therefore be seen as you can, like other evidence, you can draw the arrow to those things and not from those things.
And that's exactly what we always were, which we did originally. That's the way we tried to do it.
Yeah.
And you can indeed model dependencies between the evidence as well that way. So and that sounds great, right? And it doesn't work. In fact, because it means, for example, even in the case, we had to originally, for example, we decided, well, let's actually treat the fact that the wife is found dead and she's murdered. Let's treat that as a piece of evidence in the model. But actually, even doing that becomes unbelievably difficult to model that. And we realised that actually, why are we struggling with this, given that is clearly background information, right? So yeah, and I just don't. I mean, we wanted to do that way. That was the ideal way to do it, and it fits with of course, it fits with the naive Bayes approach, right? Not in the pejorative sense, as we've already discussed, but it fits with that approach, but it doesn't work. You just can't do it. We've tried it and it doesn't work. And in fact, it doesn't work because it doesn't actually fit to the, unfortunately, we used to think the causal structure of the problem. You know, being there and having motive caused the potential murder to happen.
So your argument here is that you are committed to understanding the arrows as causal, and therefore it doesn't work.
We couldn't. I'm being pragmatic. I'm being pragmatic. We could not. I'll tell you, we could not build. I don't think you can build ultimately sensible models that work in the way you expect them to work by just hanging the all the evidence off of the ultimate hypothesis.
But if the arrows are not viewed as causal, I mean, does your argument hold?
If they're
If we let go of the idea that the arrows necessarily have to be causal, so if something happens previously in time, then the arrow has to go from that. I mean, if we let go of that idea, is it still impossible?
I think it is, yeah.
Why?
Because we tried it and it didn't work.
I have a question about your hypothesis that Bayesian networks are actually how judges, lawyers implicitly reason. I'm not sure. I have some doubts about that, especially if you look at how, well, in my case, Dutch judges reason with witness testimony evidence. They very often like to ask themselves the question, can I believe this witness? Yeah. And if they decide yes, then they will make inferences from that testimony towards particular hypotheses. So
yeah.
In terms of causally interpreted Bayesian networks, that goes against the arrow of against the causal link.
This is the hypothesis. You've got the witness says H, right? And I said you've got the credibility, W credibility. What you've actually observed is evidence about this. Evidence of W credibility. This is also an unknown hypothesis. That was a cheat. I didn't want to complicate the talk too much by mentioning that. So what the judge observes is this. They see this guy in court, this guy is credible, that propagates to this, unknown about their true credibility, which in turn gives you the inference that you made.
Thanks, next. If you still have your question.
Yes. I like this talk a lot, but I also have another challenge for you, perhaps. So you luckily mentioned the getting the numbers issue, which I like that you mentioned that, because you even said that building a network is already useful when you don't even include the numbers. But then, of course, you lose the apparatus. But there is another challenge that I face when I work with students, and you know that Charlotte Vleck has just completed her dissertation, and probably she has used the wrong way of including exclusive narratives. But what she does work a lot on is the hidden meaning problem, if you like to call it that way. And this connects to what Phil David called the where the DAG issue. There is so much information in the assumption that you make when you build a model that it is very hard, even for the people that build the models, to understand the consequences of what they have modeled. Also in the discussions during the weekend, we had a lot of confusing discussions of what was actually the meaning of the networks that had been built. And that is useful, I agree with that, so making the model explicit is helpful. But once you have a model, there is a lot of hidden meaning there, because there is the suggestion that it is objective, the suggestion is that the arrows are, after all, maybe still causal, although they are not, etc. What about the hidden meaning problem?
Yeah, I accept it's an issue, yeah. I mean, what can I say?
The idea is that it should not be hidden. I mean, it is not.
Yeah, I mean, we try to make it explicit as possible. That's, and also that includes also making, having the states. I mean, I think again, Richard was sort of looking at some of the models that we've seen earlier and was maybe saying, well, what are the meaning of the individual states as well as the actual nodes needed to be made explicit. So it's, yeah, you can always push that to become more explicit, but there's always going to be stuff which you haven't made explicit. What can I say? We can do the best we can.
In other words,
I have two questions about motive and opportunity as well. You say that it's background information, but you must have evidence about motive. So you have to add knowledge as evidence for the motive.
And similarly for opportunity,
and opportunity as well.
And do that.
Yes, the point of motivation is quite tricky. I sympathize with some of the objection of Christian, but if you say that it's difficult, it's impossible to do that way. Okay, but second question, alibi. Alibi, you put it in among the causal factors. For me, is evidence.
Dave's going to talk about
Should
exactly
be evidence.
Dave is going to talk about that in his talk.
By a witness. I promise I'll do that. But you're right. You're right that he could have. He probably would.
Thanks. Going back a few questions. First, I definitely agree with the doubts that were raised about Bayesian networks, because once the Bayesian network gets established in the case, it will be difficult for people to think of alternatives. But on the previous question regarding reliability of a witness, one witness may make several different statements about the case, and under cross-examination one of those statements may be shown to be almost certainly false, and this then throws into doubt everything that witness has said, and so you then get, if you like, a set of closed groups.
No, you don't. You get it. That if you've got the same witness W saying something about some other hypothesis, says H dash about some other H.
Yeah.
That's the model. You've got evidence of his discredibility, back propagates here, and that again discredits what he says here as well. So it handles that.
Then you have to go back to asking new questions about the other statements that have now become doubtful.
That's okay. Yeah.
But Bayesnet takes care of that.
Thanks, Eric. Just feeds it back.
Yes.
But does that more complicated Bayesnet then have to replace the one?
No, absolutely not, because you're just seeing new evidence. You're just seeing new evidence, haven't you?
But he's asking that changes the Bayesnet.
So you've seen evidence. So
The graph is the same, but some of the variables have been instantiated now,
Yeah.
which changes the probabilities of things. But that's what the Bayesnet is for calculating. But I
we could discuss that off. Yeah, I can show you it working. Yeah.
So, at the risk of revealing my ignorance, you argue that the very strong argument that this somehow reflects human psychology, and I find this part of the first point, the point that was referred to. So, I suppose that you have networks in which parts are not logically affected by other parts. I mean, that's the assumption.
That's the problem. That's where we can't.
But
that's the thing that we can't handle at the moment.
Studies show you that once you tend to accept something, that affects the credibility and the weight that you attribute to things that are totally logically unconnected. And that's how human beings, unlike you guys, probably think.
Well, that's what Martin's going to talk
Their
about.
problem.
I am also the response.
I just think that the network shows how we should think if we think logically. What you're saying is people don't think logically. It's a different thing.
Yeah, so the problem is with humanity is with the stuff.
Sorry?
We should replace the stuff.
I'm not saying that.
Okay. Last question.
I think it's a simplification on how we should think. Because, for example, in your example, you say the witness is credible. He or she might be more credible for certain things and for other things.
Yeah, that does require a little bit more complex modelling, but we can still do it. The model is a bit more complex. Yeah.
So it's a simplification in a way we think, and we have to take this in the back of our mind.
Absolutely. Yeah.
Can I just make a follow-up on that? It's both, this is just my opinion as a typologist, it's both that oversimplification of the richness of how we think, as well as being too exacting the standard in terms of how we are frailties in thinking. So it's like got an interesting relationship. It's not just like exactly how we should think, but obviously if we can be as logical as a base net, that would be good, but actually there's lots of richness of our thinking which is hard to capture. That's what we're struggling. It's things that people can switch between narratives quite effortlessly, whereas with the base net it takes a paper 4 years to get published.
Okay, I think it's time for a coffee break now. Let's thank both speakers.